Most of you are probably a little bit familiar about Standpoint already, but those who aren't, we are a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do are our annual new laws throughout the state of Minnesota, monthly webinars for advocates such as this one, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors, and our advocates connect callers with resources, safety plan, listen, and help callers identify options and next steps. This webinar is being recorded. You can check it out on Standpoint's YouTube page. The link to recording will also be emailed out to our listserv after the webinar. For today's presentation, I'm going to share right now in the chat the PowerPoint and materials for today. So today we have our presenters, Suzanne Elwell and Amy Isenor. Suzanne is the director of the Crime Victim Justice Unit in the Minnesota Office of Justice Programs, a victim rights compliance office that investigates complaints of crime victim rights violations and victim mistreatment. She trains on crime victim related issues, coordinates and participates on statewide multidisciplinary efforts and teams, and assists with legislative initiatives related to crime victims. Suzanne has been working in the area of crime victimization for over 25 years, with experience spanning prosecution, domestic violence advocacy, and legal assistance in court monitoring and research. Amy Isenor joined the team at Standpoint in April of 2018. Amy comes to us with an experience in child protection, civil commitments and guardianships, family law, including orders for protection, dissolution, and custody, harassment restraining orders, and representing victims of domestic and sexual violence. Having worked as a prosecuting attorney and in representing respondents in civil matters, Amy's nearly 20 years of legal experience and more than that in social justice field have prepared her to advise attorneys, advocates, and victims with their legal needs. She has received numerous awards for her service to victim survivors. So now I'm going to pass it off to Suzanne and Amy.
Thank you, Jay. Thank you so much for being here, everyone. It is Sexual Assault Awareness Month and National Crime Victim Rights Week. So we'll be talking about crime victim rights, and what better specific group to talk about than sexual assault victims. We're so excited to have Suzanne with us. Thank you for being here and for bringing all of this information to us.
Thank you, Amy. I appreciate you inviting me to present with you. We have attended many meetings together as in our work with the Criminal Sexual Conduct Statutory Reform Working Group, but this will be the first time that we've ever presented together. And I'm relieved to have somebody else besides myself talk through a presentation about crime victim rights. And I asked Amy if she would tell all the jokes, because I didn't feel very funny today. And so I promised to laugh at them. So I hope you all do as well.
You can laugh and it will make me feel better.
Okay.
They can. So you can laugh out loud.
So today we're going to be looking at do an overview of the Minnesota Crime Victim Statutory Rights Scheme. We are not going to go into detail about any of them. If we wanted to, that would take about 2 days. So we have one slide on a topic where I could talk an hour on that topic. So we're not going to be diving deep into each one of those, but instead give an overview. But we did want to highlight those crime victim rights that are specific to sexual assault victims. Also want to bring in those pieces of on the civil side of our justice system about those protections for victims, as well as the data protections and strategies to protect victim confidentiality. So I'm going to hand it off first to Amy to do an overview of the civil protective orders available.
So like Suzanne said, most of our presentation is going to focus on the criminal side. What rights do crime victims who are sexual assault victims have? But we know that nothing happens in a vacuum, and that when clients come to us, we are helping them with all kinds of other options, and all kinds of balls are in the air at the same time. So we want to remember the civil protective orders, either an order for protection or a harassment restraining order. Both are available to a victim of sexual assault based on one sexual assault alone. However, when we're looking at the order for protection, again, we're always looking at what that relationship, are they a household or family member as defined in 518B.01, and it lists the specific people under that statute that do qualify. This order can be really broad. You can get a lot of different relief from it, but that can also come with some cons. We want to be careful when we're looking if there's an intimate partner sexual assault, that we might not want to file an order for protection just because the client qualifies, because it could raise issues of custody or housing or other issues could come up that we don't want addressed. So maybe the HRO remains the better option. So to get an OFP, you have to allege physical harm, bodily injury or assault, or fear of imminent bodily injury or assault, terroristic threats, criminal sexual conduct, or interference with an emergency call. That criminal sexual conduct does, I believe, include revenge, non-consensual dissemination of private sexual images, and some other sexual things that aren't necessarily a straight sexual assault. But it has to fit under that definition specifically, and it has to fit under the crime definition for an order for protection. Harassment restraining orders include all kinds of other things, including anything that interferes with the victim's safety, security, or privacy. And they're going to be available to most victims who are not victims of intimate partner violence. And so we want to remember that this is out there as an option for them as they're choosing whether to report or not, and talk through the pros and cons of each option with them so they can make the best informed decision. The relief in an HRO is only no contact and no harassment. We've seen judges order other things, but there's no statutory authority for it. But things like posting on social media or talking about them, we have seen judges order that can't happen. But statutorily, they can only order no contact or harassment. Go ahead.
Okay.
Unless you have anything to add on that one.
So let's talk first about what we mean by crime victim rights. In Minnesota, under Chapter 611A, we have what's called the Crime Victim Bill of Rights. Even though we call it a Bill of Rights, it is a statutory scheme. It is not a constitutional amendment. And 611A has the set of core rights that we see within the criminal prosecution system. The fact that we don't have a constitutional amendment doesn't mean that we don't have strength in our statutory scheme, but what is missing, because we don't have one, is the language you might see in other states that have constitutional amendments, like victims have a right to be treated with fairness, dignity, and respect. We don't have a broad overarching statement like that within our scheme, which we think is a gap, but we do have some strength in our statutory scheme. The first is that our crime victim rights apply to all crime victims, whether they're committed by crimes are committed by adults or juveniles, and whether it's a misdemeanor or a felony crime. Most of our pretrial crime victim rights are automatic, meaning the victim doesn't have to say, I want to opt into the system, I want to get my rights. They are supposed to be given to them automatically, primarily by the prosecutor. But most post-conviction rights are going to be an opt-in situation, meaning the victim has to ask to be given a particular notice, for example. Another strength of our scheme is that it does have a victim rights compliance office, the Crime Victim Justice Unit, which operates as an ombudsman. The Crime Victim Justice Unit was originally called the Office of Crime Victim Ombudsman, and it was reorged into the Department of Public Safety in 2003. An ombudsman is a place where people can go and complain about their government, in this case, a prosecutor's office or law enforcement agency. And we can identify rights violations, but we can't force subject agencies that we investigate to adopt any of the recommendations that we have. And that's a weakness, as well as some other weaknesses. In our statutory scheme, there's no penalty to a criminal justice professional for failure to provide the rights, statutorily required rights. Victims cannot sue a criminal justice agency for failure to comply with the statute. when a right is violated, there is no do-over. There is no mechanism within our criminal justice system to go back to a plea hearing, for example, or back to a sentencing hearing if the victim was not given proper notice of those hearings or notified of a plea agreement being presented at a hearing. We can't go back. And then we also have practical challenges to affording crime victim rights in misdemeanor cases, merely by the nature of the way that they get processed. They are quick, and oftentimes it's hard for prosecutors to comply with those rights because of that, the speed at which they are taken care of. So to review, what happens when victim rights are violated? There's no penalty. There's no legal recourse. There's no do-over. And I was looking for one more word and I found it. There's no recompense. So recompense means making amends to someone for loss or harm suffered. So if a prosecutor fails to give a victim notice of a plea agreement prior to being entered, then says, oh, well, you can just talk about it at the sentencing hearing in your victim impact statement. That is not really making amends. That victim has lost that opportunity that they had, and saying that you can do it later is not really a viable option. There's no recompense for that victim. Typically, apologies don't provide any recompense when a prosecutor fails to provide the required notices. So we have a scheme where we can't enforce crime victim rights obligations, but we can seek to get compliance. That's what a lot of the work that we do. And we can work really hard in trying to prevent crime victim rights violations. And so I always talk with victim advocates about the need to be crime victim rights violation prevention specialists, that you are agents for prevention in crime victim rights. Keeping in mind that when we talk about this prevention work, making sure that victims are not harmed in the criminal justice system, that applies equally to all the work of victim advocates, trying to prevent bad things from happening in an OFP hearing by working with that victim, educating that victim, and preventing harm to the victim because you work ahead of time to make sure it doesn't happen. So I'm going to turn it back over to Amy, and we're going to start talking about rights and the victim's experience through the criminal prosecution process, starting with law enforcement intervention.
So, as Suzanne was saying, those relationships and our ability to do prevention to prevent crime victim rights from not being violated is to have positive interactions and relationships with the community partners that we work with, particularly system partners. So law enforcement, the government, anybody in the government is the system partners. So being on interdisciplinary teams, starting a domestic violence or sexual assault team in your community that includes prosecution and law enforcement and probation and social workers and hospital, all the people who are responding to this issue in your community. Working with law enforcement ahead of time to have a really good relationship with them where they understand your role. So knowing them individually, like your ED might know a detective, they have a good relationship back and forth, but you working with a particular officer occasionally, knowing them by name, helps to move this along. So it's important for us to explain our role to them. If we want to participate in an interview, to be present with a victim while they're being interviewed by law enforcement, that victim does not have a right to have us there. There is no statutory right for a victim to be present, an advocate to be present during an interview. So what do we do to prevent that? We work ahead of time to develop those relationships. We let law enforcement know what our role is. We're not there to babysit them or make sure they do their job right. We're not there as an enforcer or gonna come gripe at them afterwards. We're there as a support for the victim. We're not gonna interrupt. We're gonna be quiet. We're not gonna interfere in any way with the interview or the investigation. We're not gonna prompt the victim of what to say or give them hints or coach them. We're just there as a supportive role. If we interrupt, it's maybe because the victim can't move forward and we recognize they need a break, and we ask for a break to get some water or offer the victim an opportunity to use the restroom. But we're not interfering in that conversation itself. Also, it can be really helpful to have an advocate present, because just like if you go to the doctor, I'm going to the doctor this afternoon, I've had some testing done, I'm concerned they're going to tell me I have a bad diagnosis, right? I want my friend to be there with me as a second pair of eyes and ears, because I'm traumatized by what's happening to my body and what they're telling me the next steps are, right? A victim is traumatized about having to tell their story, and they might not even be present in that room while they're telling that story. They may be back at the incident where it happened and not able to hear anything the officer says. So being that eyes and ears for them to explain, interpret, or remind them of what happened afterwards is really important. Similarly, victims don't have a right statutorily to have a parent present during an interview. A child has a right to speak with law enforcement without their parent present. The 17-year-old wants to make a report, they don't have to bring their parent. If a parent won't allow a child to interview with law enforcement without the parent present, law enforcement can refuse to take the report. However, oftentimes when child victims are involved in a sexual assault, it's often also a mandated report, and child protection may be involved. If that's the case, law enforcement or child protection can go to the school, daycare, or other places to interview the child without the parent even knowing. So we want to remember what's best practice versus what's a right. The whole goal of working with law enforcement and having these relationships is that at the end, law enforcement recognizes that interviews go better when you're there. They want to invite you to the next interview if a victim isn't already working with an advocate, because they recognize the strengths that you bring and that you're not interfering with their role. You can go to the next slide unless you have something to add. So during the law enforcement interview, what can we do to minimize harm? We know the victim is going to be traumatized. It is going to be a hard interview. There will be questions asked that don't feel good. So we need to think about what is the role of law enforcement. Their role is to investigate, to gather information, to do a fact-finding mission, then also to anticipate holes in the case. I'm trying to build a case, I'm taking your report, I'm going to do an investigation and determine if there's charges to bring to the prosecutor. I want my report to be good. What are the holes in my report going to be, and how can I prevent that? So I'm going to ask questions that I might anticipate the accused person is going to say or claim. And that might feel really bad to a victim. It might feel like victim blaming. So reminding the victim of what the officer's role is and what their job is. Victim blaming sometimes does happen. Not all law enforcement is trauma informed or does a good job interviewing, but sometimes it might just feel like it's happening when it's not actually the intent of the officer. For example, they need to know the details of the report. So if they ask, what were you wearing? That feels victim blaming if the victim was wearing a skirt and feels that she's going to be accused of wanting to engage in a sexual encounter because of how she was dressed. But the actual question might be about how did the perpetrator access the place that you're saying they contacted you or they harmed you. I need to be able to visualize this and just describe it in my report. So I need to know more. They might ask the same questions over and over in different ways. They might be trying to spark the victim's memory to make them remember something different, or there are cases where they're trying to trick the victim and get them to say something inconsistent if they don't believe them. That's not their role, and we support law enforcement in doing these investigations. We support victims who want to report. So we want to do as much as we can in developing that relationship with the law enforcement agency, but also preparing the victim for that. We can prepare them about some of the myth busting kind of issues. They might be asked if they were consuming alcohol or drugs. They might be asked the kinds of questions. Did you say no? Did you fight back? Did you yell? And having a relationship with law enforcement ahead of time, where you maybe do a training on counterintuitive victim behavior. You maybe talk about why the victim might not do what they expect a rape victim to behave like. But they might also ask those questions. And so just informing the victim ahead of time supporting them in how to answer those questions. Did you tell anyone? Did you leave the scene immediately? Did you have contact with the person after the fact? The victim might feel accused in those questions. So it's important that we're there to be supportive during the interview. It's important that we're there to be supportive after the interview to help them reformat that in their brain. Don't be confrontational with an officer during an interview. If they allow you to be present and something's going wrong, don't say, you can't ask that, or try to confront them in any way. Talk to them afterwards, remain an ally, and talk to them one-on-one so you can continue building those relationships. Again, the goal is getting them to invite you, to want you there, because advocacy, being present during law enforcement interviews, is supportive for the case as well as for the victim.
All right, so we had law enforcement intervention. One thing that used to happen was a law enforcement investigator would ask that the victim take a polygraph examination. Some years ago, a law was put in place that prohibits the requirement of a polygraph examination on the victim in order for the case to proceed, either the investigation or the prosecution of a case. The victim can request to take a polygraph exam, but they must give written informed consent so that they can say that informed consent means taking the polygraph is voluntary and at the victim's request. A law enforcement agency cannot ask or require that the complainant, the victim, submit to a test, that the results of that test are not admissible in court, and that the refusal to take a test cannot be used as a basis for not investigating or prosecuting the case. At that initial law enforcement contact, one of the most important rights that we regard as the most important is the initial notification of rights. Law enforcement officers are required to distribute a notice of rights and information to all crime victims at initial contact. And that statutory requirement has a list of what's required in that initial notice of rights. There's information about some of the rights under 611A, but also resources. In different jurisdictions, it might be referred to as something differently, called the blue card in Minneapolis, because they printed on a blue cardstock. Other places, it's the victim information card. But it's important that this get distributed because not all cases are prosecuted. This might be the only time that a victim is given information about where to get contact a domestic violence agency or how to file for reparations. Reparations information is required to be on this card, and reparations doesn't require that the case be prosecuted. So this might be the only way that the victim will find out about reparations. The Crime Victim Justice Unit helps law enforcement agencies design, review, or update their victim information cards. We have information on our website about how to make that request. We know, and we routinely get inquiries from advocates about their local victim information cards, because the advocacy organization or the county attorney's office, the advocate there, might be helping with developing these victim information cards. And that's great that there's that local assistance to the law enforcement agency, but keep in mind that it is the law enforcement agency's responsibility to print it, to distribute it. It's not the advocate's responsibility, it's the law enforcement agency's responsibility to make sure that they have up-to-date cards and are distributing. If the victim has gone to the hospital for a forensic exam, there is a notice that is required to be given to the victim by the hospital. That information is contains crime victim rights, information about reparations, advocacy services, and information about the payment for the forensic exams. And we'll talk about that in a moment. This notice is, we have a template on the OJP website for hospitals in 4 different languages. And it has been updated actually since this photograph was taken. It's updated with the newest information about forensic exams and what's happening in Minnesota. But if you want to look at it, you'd find it on the OJP Help for Crime Victims page, professional resources. So for forensic exam, under Minnesota law, the cost of the sexual assault evidentiary exam conducted for the purpose of evidence collection is to be paid by the county in which the sexual assault occurred. So if the sexual assault occurred in Wright County, but the victim went to Hennepin County for the exam, then Hennepin County the hospital would seek a payment by Wright County, as an example. This statute does not only applies to the exam costs. It does not include the cost of any treatment for injuries related to the sexual assault.
Suzanne, is the victim required to report to law enforcement and begin a prosecution process for it to be paid for?
No, they do not have to report it to law enforcement.
Thank you.
In 2020, the law changed with regard to how it's actually changed a couple times. The most recent and most important change had to do with what we do with restricted versus unrestricted kits. A restricted kit is a sexual assault examination kit where the victim has consented to have the kit tested. For those kits that have not consented to have the kit tested, if it's a restricted kit, it will be submitted to the BCA and stored for at least 30 months. So prior to this, those kits might have been stored at a hospital, the kits might have been stored at law enforcement agencies, but as of 2020, now they are sent to the BCA and stored. An unrestricted kit is one in which the victim has given consent to have the kit tested. There's a requirement on law enforcement to submit that kit to the BCA for testing within 60 days of receiving the kit. There's also a victim has a right to request information from the law enforcement agency for kit status. So upon a request, the victim or their designee can ask for the following information: the date that the examination was submitted to the lab, the date that the agency received notice of the results, and whether a DNA profile was obtained from testing. Keep in mind that this is active investigative data, which is normally confidential and not released. If the agency feels that it might interfere with the investigation, they can say no. Each agency is supposed to have a policy in place about how they are going to respond to these requests from sexual assault victims. Has been put in place some years ago, but now as of 2020, with that new legislation, there was a new requirement that was put in place stating that the BCA shall maintain a website with a searchable database for sexual assault victims to find out the status and location of their kits. This new system is almost ready to go statewide. It's in the testing phase, the pilot stage up in St. Louis County. It's called Track It. It's administered by the BCA, and victims who go into the hospital to have a forensic exam, at that time, they're going to get information about how to log into the Track It system, get their personal login credentials so that they at any time can go onto the website and find out the status of their kit through the system. That is due to be launched late June, early July. And so the BCA has changed all their procedures about how they're labeling kits and putting codes on so that they can track that kit throughout the system. All right, I'm going to move it over to Amy to talk about immunity from prosecution.
So in an effort to encourage reporting of sexual assault and allow for bystander intervention to call law enforcement, even if the bystander or the victim have been committing some minor crimes, the immunity from prosecution statutes were put into place and are effective as of August 1st, 2021. So a person who reports a sexual assault, a bystander or on witness, may not be charged or prosecuted for illegal drugs, being under the age of 21 and drinking. But in order to qualify for this immunity, they have to be the first person asking for assistance. They have to give their name and contact information to law enforcement, and they have to remain on the scene to be available to make a report. The person who experienced the sexual assault also may not be prosecuted or charged for underage drinking or illegal drug use. For the victim, they also cannot be revoked from probation or conditional release from jail or prison. So these immunities are put into place to encourage reporting and to support people coming forward and getting help without fear of retaliation or charges themselves. Back to you.
All right, so we've had our law enforcement response. We're starting, it's been sent to the prosecutor. Prosecutor's reviewing that investigative report and making a decision about charging. If the prosecutor decides not to file charges, they must notify victims of domestic violence, stalking, and criminal sexual conduct of that decision to decline. And then provide information about OFPs and HROs. There's also a corresponding notification right if charges had been filed and then the prosecutor decides to dismiss those charges. Notice also has to go to the victim of the notice to dismiss those charges and provide reasons for that decision to the victim. So prosecutor decides to file charges at the start of the case. The prosecutor has a notification obligation. So we had the initial notification on the part of law enforcement at first contact to the victim, giving certain information and some resource information to the victim at that point in time. And now at this point in time, when filing charges, the prosecutor has an obligation to notify victims of the fact that charges have been filed, and they must notify victims of all the rights under Chapter 611A within a reasonable time after the offender is charged or petitioned. It's typically by letter along with notice of charges being filed. The important piece of this in this moment of time, again, is the opportunity to provide information to the victim about reparations, making sure that they understand that they can file for reparations if they're victims of violent crime and have loss related to that. We'll be talking about reparations specific to CSE victims in a short while.
CSC is criminal sexual conduct.
Well, thanks.
Sexual assault.
So if there's a pretrial release hearing, say the offender has been arrested, is in jail, they're going to have a hearing. The court has an obligation to make a reasonable and good faith effort to notify the victim of the release from pretrial detention. They must notify them of the hearing date, time and location of pretrial detention, the person to contact for more information, and the victim's ability to attend that hearing. This is most likely done by pretrial services is getting this notification. At the same time, there's a requirement for prosecutors to present evidence, relevant information involving the victim or the victim's family account of the alleged crime to the judge in determining the arrested person's pretrial release. Because of these two kind of hand-in-hand requirements, sometimes victims do get two calls prior to this pretrial release hearing, where they'll get one from pretrial services and another one from the county attorney's office. Moving over to you, Amy, with statute of limitations.
So in September 14th, 2021, just a few months ago, well, it's getting to be a lot of months ago now. Time is going really fast this year. The criminal sexual conduct statutes were amended to change the statute of limitations for criminal sexual conduct crimes. So for criminal sexual conduct in the first through the fourth degree, if it occurred on or after September 14th of 2021, there is no longer a statute of limitations on that crime. If it happened on September 13th of 2021, the previous statute of limitations applies. For criminal sexual conduct in the fifth degree, it is still a 3-year statute of limitations. So it is not retroactive. It does not go back to crimes committed prior to September 14th. And the crime statute of limitations depends on the statute date at the time of the offense. So statute of limitations often change, and often, particularly for minors, have changed over time. MinCasa does have a nice chart, which we've included in the Dropbox. that goes through the previous statute of limitations. It is not updated to the current statute that talks about the fifth degree specific, and then the no statute of limitations for first through fourth. So just remembering that the statute of limitations is on the date of the offense, not now.
So that chart is still very useful because you're still looking at crimes that occurred prior to September 14th and analyzing if the statute of limitations has expired.
I get calls all the time and I look at that chart all the time. It's very helpful.
Right, just in general, victims have a right to be informed of the prosecution process. It's kind of a vague overarching statement without a lot of specifics, but that is found in 611A.02. Victims also must be notified of plea and sentencing hearings. That's found in a variety of places. And victims should be notified if there are changes in court proceedings scheduled, if they were asked or subpoenaed to testify. One of the gaps in here is the lack of clarity about other hearings besides plea and sentencing hearings, or those in which they've been subpoenaed or requested to attend. Many prosecutors' offices, as a routine process, notifies victims of all the court hearings related to the case, and that's considered a best practice. Not all prosecutors' offices do that, and sometimes we get complaints from victims about not getting notified of a hearing, even though it's hard for us to say there is no statutory right to that. We do fall back, though, on the belief that in order to be informed of the prosecution process, to participate, you have to know when the hearings are. So we encourage prosecutor's office to do that, to notify of all hearings. In the pretrial stage, victims of violent crime and domestic abuse have an automatic right to get notified when a person is going to be released from a jail or custodial facility. This applies to both adult offenders and juvenile offenders. This notification has to be provided orally to the victim, including the time of release, conditions of release, next court appearance if known, and relevant crime victim services. And this must be followed up by a written notice as soon as practicable. In addition to this requirement on jails to provide this notification to domestic abuse and victims of violent crime, there's also a service in Minnesota called VINE, Victim Information and Notification Every Day, which is a service available to victims and others. So it's used often by criminal justice professionals, by advocates and others who are interested in what's happening with a particular offender, as well as family members of the victim or the offender who is incarcerated. So this VINE provides two important features. One, you can go into VINE either by calling the phone or going to the website and finding out, is this person in a jail in Minnesota? Right now, 99.5% of all jail beds in Minnesota are connected to the VINE service. So if you do that one search, you can find if that person is in a facility in Minnesota. And if they're in that facility, you can make a request that you be notified when that person has a change in custody status, whether they're either released or they're transferred. Under the new system, the enhanced version of the VINE service, enhanced VINE is what we refer to it, there's an additional feature. So it used to be that if you transfer a jail inmate transfer to another jail, another county, the registration to get notified ended. Under our new service, we have a way to connect the original registration, say in Hennepin County. If they get transferred to St. Louis County, that registration stays alive and the victim does not have to re-register to get notified. So this service is free. You can get a request to get notified by email, text, or telephone. It's anonymous and confidential. The notifications that go out in Minnesota are in English, Spanish, Somali, and Hmong. However, the website, if you go to vinelink.com, it has 16 different languages that can be, you can click on to choose one of 16. And so there are a lot of opportunities for other languages as well to go and navigate the website. The other thing about the enhanced fine service is that it has additional features for those who, different features for how people might want to get notified. So instead of getting notification, a victim might just want to create an account and look in and see what the status is. Or an advocate might want to create an account and have a way to organize all the notifications that they might be tracking because they have many offenders associated with the victims they serve. And they can create an account that makes it easier to manage those registrations and view those registrations. So I encourage you to go to vinelink.com and do some exploration if you haven't for a while and see those new features. Another right during the time that the case is being prosecuted is the victim's right to terminate a lease without, actually not during prosecution, in general, terminate a lease without penalty. This applies to domestic violence, CSC, criminal sexual conduct victims, harassment, stalking victims, and sexual extortion victims. And if the victim must provide advance notice to the landlord and still has some liability for rent, and their privacy protections on the request to get out of the lease without penalty. Victims also have rights to protection against employer retaliation. This applies to persons who want to take time off to attend OFP, HRO, or criminal proceedings. There's some conditions about providing advance notice and supplying verification if requested as well. Reasonable time off isn't defined, but it might depend on the employment. The question is, how do we enforce this particular protection? This is something that if it becomes an issue, the prosecutor can notify the employer of this right. The Office of Justice Program, the Crime Victim Justice Unit, has developed a set of sample prosecution letters, and it has every conceivable letter that might go out from a county attorney's office or a city prosecutor's office, notifications and all sorts of different scenarios. But one of the sample letters is about notifying an employer of this right of a person to take reasonable time off to attend these proceedings. So a county attorney can send that to an employer just to notify that employer that this right exists if the victim is having trouble exercising this protection.
And they can be charged if they violate it.
And there's a nice little thing about criminal charges, and that's why it is nice for that letter to come from the prosecutor's office, because they would be the ones that would have the authority to pursue that.
It's one of the few rights that victims have that has a teeth attached to it.
So continuing on in our pretrial phase, victims have a right to a safe and secure waiting area. This is a responsibility placed on the court. However, we know that most of the time it is the prosecutor who is making arrangements for the victim to be in a place that's safe and secure and away from harassment from other potential witnesses and different things. This is something, though, if it is really a problem, this is where you can go to court admin and say that they need a safe and secure waiting area and they need to provide one, because they're the ones that are required to provide that space. Victims in CSC cases, there are a number of provisions related to having a support person present. So a minor victim in a case involving child abuse, 5th degree assault, domestic assault, and crime of violence, including CSC cases, may have in attendance a parent, guardian, or other supportive person during the proceedings. A victim of CSC, not including 5th degree, may choose to be accompanied by a supportive person at the omnibus or other pretrial hearing. And a minor CSC victim may be accompanied by a parent or other supportive person while testifying before a grand jury. So these are the specific statutory provisions related to support persons. It doesn't mean that a person couldn't attempt to have a support person in other contexts and see how it goes. You know, this just is the one that protects in those circumstances. All right, one of the things that often comes up during a criminal prosecution is an attempt to get victim records. So I'm going to turn it over to Amy to talk more about that.
So victim records could be requested from a lot of different places, from educational facilities, medical facilities, psychological facilities. Particularly the one that comes up and that we're going to talk about now is from advocacy agencies. If either the prosecutor or the defense chooses to try to get information about the victim, pursuant to the Minnesota Rules of Criminal Procedure, they have to file a motion with the court asking for permission to issue a subpoena, and then the court issues the subpoena by court order to the privileged the person who has privilege with the victim. So the victim has lots of relationships, some are privileged and some are not. So if they want to get privileged and confidential records, they have to follow this rule. We have a privacy memo that Raina and others in the movement have worked on drafting over the years. It is attached in the Dropbox and goes through each step of different things that could happen for an agency to be requested to provide victim information. But what can we do from the front end, again, to mitigate and to prevent harm to protect victim records? First of all, we can not create them. Keeping as little information about a victim as possible is best practice. You may need to keep certain information for specific grant reporting, or a grant may require that you have some data. If you're working with a person for a long time, you might need some notes so you remember what's going on. But thinking about, what am I putting in this document? What information do I have in here that if it were ever obtained, God forbid, by a subpoena, or even if the victim chooses to release it, what is it going to have in there? So if I'm doing in a shelter, a log that goes between day staff and night staff, I'm not putting my opinions in there. I'm not saying, oh, so-and-so was such a pain today. I couldn't believe she did this and she said this, and I don't even believe that's true. Now you have a credibility issue of your opinion from you having a bad day going into records that could be obtained by somebody to use against her, that she's not credible. Your opinions don't matter. Your thoughts don't matter. If you say we worked on housing and she's looking at these 3 specific addresses and that gets to the defendant, that's a lot of information. You could just say met with initials, talked about housing. So the less that you put in your notes, the better. Think about, why are you creating the record? Is it required by your grant? What information do you have to include? Don't ever include your opinion or your thoughts. And don't write down victim quotes. So-and-so said, quote, end quote. If you ever are subpoenaed, contact Raina. She will fight it. We have a case up at the Supreme Court right now with Hope Coalition, where their records were subpoenaed and the victim does not consent to them being released. And we're hoping for a really good result. The arguments have been done, so keep your eyes out for that order in the next couple of months here. So when we look at 611A protections, this applies to all crime victims. It applies to all service providers who receive an OJP grant. So this protects personal history and other information collected by us, service providers, and maintained by OJP grantees, us again, from which the identity and location of any crime victim could be determined, is considered private data and it can't be released. So it's under the Data Practices Code 611A statute, and it is protected. Under other protections, specifically sexual assault victims have a right to protection when they're working with sexual assault counselors. All sexual assault communication data is classified as protected data for individuals when, when they're working with a sexual assault counselor. And this is under 13.822, which is not our specific privilege statute, which is even stronger. But under this applies to all community-based sexual assault crisis counselors, crisis centers, advocates, whatever we call ourselves. The statute says sexual assault counselor. We typically say sexual assault advocate. It's interchangeable. So when we look at who is a privileged sexual assault counselor, in order for the victim to have privilege with you, which is a really, really strong standard, it's much stronger than confidentiality. There's two kinds of privilege, qualified and absolute. And our argument and Standpoint's position and the position of the people working in the movement in Minnesota is that sexual assault advocacy privilege is absolute. So are you a sexual assault counselor? Is everything you're talking with your client about privileged? If you have undergone the 40 hours of crisis counseling training, which you've all done to have your jobs as advocates, and you work under the supervision of a sexual assault crisis center, everything that you talk with your client about is privileged, and you may not, under any circumstances, except for 3 exceptions, disclose any information about the victim. The victim can consent and sign an informed, knowledgeable release of information to allow you to release their information or talk about them. A mandated reporting situation, if you believe that you are a mandated reporter, or your agency tells you that you are, and a court order compelling disclosure. If that ever happens, that court order, you're again going to be calling a lawyer to try to quash that and fight that because of absolute privilege. So that's who qualifies and the 3 exceptions of when information can be released. So during a prosecution, is that the next slide? Thank you. So this is where we talk about this absolute privilege. Minnesota Statute 595.02 subdivision 1 parentheses K says that sexual assault counselors may not be allowed to disclose any opinion or information received from or about the victim without the consent of the victim. This is an absolute privilege. In this same statute, it talks about doctors and nurses and all kinds of other A through K, right? And the ones after us. And in there are exceptions for some of them. It can be used for this purpose. It can be used for this purpose. In the sexual assault advocate statute, there is no exception. This is an absolute privilege. And this applies even if you're called to testify. So there's 2 kinds of subpoenas, a subpoena ducis tecum, is that how you pronounce it? That's how I've pronounced it. And a subpoena to appear. The subpoena ducis tecum is requesting documentation or paperwork records. The subpoena to appear is to come to the court to testify. If you get either one, call a competent attorney or Standpoint, and we will get you to one to fight it. All sexual assault communication data is classified as private data on individuals. We want victims to be able to come and tell us anything, and we're going to fight to protect that no matter what. Let's see. So when we have prosecutor meetings, there's lots of times where a victim may be called in to talk with the prosecutor, and Suzanne's already talked about several of them. But when we're thinking about confidentiality, what do we need to think about in that circumstance? And what we want to think about is who's there, and does that create a confidential situation? The client has confidentiality with me, right? But I'm in a room with other people. There is no confidentiality between a victim and a prosecuting attorney, and there's no privilege. There's no confidentiality between a victim witness advocate that works for the systems and a victim. With a community advocate, you still have confidentiality. So under the statute, you cannot disclose information you learn during that prosecutor meeting, even though someone else in that meeting could disclose it. Your privilege remains absolute. So the victim needs to know that. And again, there's no right for a victim to have an advocate present with them while meeting with the prosecutor, but it is best practice. Again, encouraging those ongoing relationships ahead of time moving forward. Making sure that the prosecution knows your role and that you're not there to intervene or interject. making sure the victim knows that it's not confidential, not there's Brady exceptions. Any exculpatory information is going to go to the prosecutor, which will go to the defense attorney and ultimately to the defendant. So there's always safety concerns we need to consider too when having these meetings, when information could be divulged. And again, you still can't say anything. When I do my confidentiality training, maybe some of you have been there, my ultimate role, my ultimate thing at the end of the day is zip it, keep it shut, don't talk. Even if you're working with child protection and you've made the report and then they call you to say something, you can't disclose that. Even though you don't have a confidential or privileged relationship with child protection, it is about your client. You cannot disclose anything. It's a strong right that victims have. Strong one.
All right, so we're still in the prosecution process, and here's my favorite topic, which is plea agreements. A victim has a right to be notified of a proposed plea agreement prior to it being entered into the record at a plea hearing. And this is one of the biggest, most frequent complaints that our office gets, is the failure of the prosecutor to notify the victim of the proposed plea agreement prior to it being a done deal, meaning it's the document's been signed, it's been filed, and the defendant has said on the record, yep, I plead guilty based on this plea agreement. This requirement is supposed to happen prior to the presentation of the plea, but also in this moment where the prosecutor speaks with the victim and lets them know about the proposed plea agreement, they're supposed to let the victim share what they think about it. Do they agree with it or not agree with it? If they don't agree with it and they can't attend the hearing, they can ask the prosecutor to let the judge know about their objections to the proposed plea agreement. If they want to attend the hearing, they can attend the hearing in person and say, I object to this plea agreement. They can also submit a document in writing saying, I object to this proposed plea agreement. The prosecutor is required to make a good faith effort for this. And we know that many times pretrial hearings get converted into plea hearings and sometimes even into plea and sentencing hearings. And when that happens, all sorts of rights, and the victim isn't notified, all sorts of rights are violated. If the victim isn't told about the proposed plea agreement and the fact that there's a plea hearing and they have a right to attend the hearing and they have a right to object, not telling the victim means that they've lost a host of rights. And if they move to sentencing, then they've lost the right to be present at sentencing and to give a victim impact statement. There's a lot that we can speak to about how to prevent this kind of violation. And it means about educating victims about what they can do to make sure that communicating well with the prosecutor, making sure the prosecutor knows that the victim will be attending or wants to attend these proceedings. I just had a complaint this week from a victim who said that we had a trial set for Monday. And I went to the trial and I sat in the courtroom and I thought there was going to be a trial, but it turned out to be a plea agreement. And the prosecutor, who doesn't know what the victim looks like, and the victim who had never met the prosecutor, they didn't make a connection. And so they went right into a plea agreement, put the plea on the record, and the prosecutor said, let's continue for the sentencing hearing because we know that the victim wants to give a victim impact statement. When the victim came home or left the courtroom, looked at her phone, and that's where the phone call for notifying her of the proposed plea agreement there was an attempt to let her know as the hearing was going on. So there were a couple things to unpack with that, which is if the victim had known what to do before the hearing, this might have been prevented. If the prosecutor had let the victim know ahead of time that, this is, if you're coming to the hearing, let me know, this is what I look like, other ways to make those connections, that maybe that would have been prevented. In this case, the prosecutor, I know from experience, is a person who generally complies with the crime victim rights, and this was a misconnection. So, but there are a lot of variations on the theme about how this doesn't happen, and we spend a lot of time talking with victims about this particular failure of prosecutors to provide this right. I think in more serious cases, the CSC cases, that it's often the case that the prosecutor will have a meeting with the victim ahead of time so that they have time to talk through what the possible outcome or proposed outcome and will be, and the victim has a chance to provide, ask more questions and get more information about that case. But that isn't necessarily happening in all CSC cases. So once that plea is put on the record, there might be a pre-sentence investigation where the victim has a right to provide input into the pre-sentence investigation, and that PSI then gets presented at sentencing. The victim does have a right to be at sentence and be notified of the right to be at the sentencing hearing, or notified of the date of the hearing. The victim has a right to give a victim impact statement as well as to request restitution. And as I said earlier in the presentation, I have one slide where I could actually talk an hour on that, and this is one of those. Victim impact statements are also something that is common for them to be violated because of the situation of pretrial hearings getting converted to plea and sentencing hearings. But the right itself is that a victim has a right to submit a sentencing at statement, orally or in writing, or they can ask that the prosecutor or their designee read that out loud at court to talk about the impact of the crime on them. I can tell you when this right is violated, victims are very upset. They feel re-victimized by the system, and they feel especially upset if they have been cooperating all along, have maintained communication all along, and have had expressed an interest. These are not people who want it to go away. These are people who are very interested in the outcome of the case. And when they aren't given their chance to give a victim impact statement, they are very upset. I just wanted to point out that on the OJP website, professional resources page, we have a brief that was prepared by the CVJU and the Minnesota Alliance on Crime that talks through all the issues related to victim impact statements, the various ways that they might get introduced in different jurisdictions, the ethical issues regarding victim impact statements, and best practices. So I'll just direct you to that document.
Suzanne, we had a question come in, and I think it's appropriate here. It's right on topic. What are some strategies to protect victim rights when it comes to Zoom and accessing hearings? For example, today an advocate and victim were in a waiting room. Court personnel were notified we were there waiting. The hearing happened, and the court personnel told us they were given instructions to not let us in the courtroom after the hearing was over. What can we do in these situations, and is this a violation of a victim's rights?
This is, well, on the first answer, boy, this is one where we want to prevent this from happening, and this means communicating with court personnel, court admin about the procedures, what's going to happen, and making sure that there's an understanding of the fact that the victim's going to be there, they want to speak, and all these different things. So having good understandings about the process on all parts, whether it's the judge, whether it's the clerk who lets people in, or whatever. So there's that. What do we do now? This is, if somebody is there and they were denied their right to be present, this would be a communication, and it's the court. This would be a communication to either the judge or it could be the court administrator, because if it's a procedural thing, we don't have our Zoom hearings figured out yet still, that you have to get this figured out because you're denying people their rights. Then it's a communication with court admin and those who are responsible for setting up the Zoom hearings, and say, how are we going to fix this so it doesn't happen again? If a statement wasn't given because they weren't allowed in the room, then it's a statement, then that's a letter, file a victim impact statement if that's what it was, to make sure it gets into the court record, if that's what the victim wants to do. The other piece of that is always report issues that we're seeing in these kind of cases to our contact at the judicial branch, Malia Garza, who acts as a liaison for domestic violence and sexual assault issues with the branch, and say, this is the experience that's happening. Maybe this is an anomaly, or maybe this is a problem within that jurisdiction that needs to be addressed, and seek some help in that way as well. Amy, do you have anything else that you might suggest?
No, exactly the same thing. It's concerning that they were actually denied. They didn't just like miss it. They were told no.
Yep, this is a public hearing. You can't do that. That's kind of, no. All right, I just wanted to highlight 3 rights that happen near the end of the case. We have the right to give input into the PSI when the agent is preparing that PSI. We have a right to object to a proposed plea agreement, and we have a right to give a victim impact statement. These are 3 separate rights at 3 different moments of time for 3 different purposes. And I think sometimes in some counties, they kind of merge 2 together, and they'll say, well, the input into the PSI, that's the same as the victim impact statement. They're not. They're 2 different things. Sometimes when, as I said, the victim doesn't get to object to a proposed plea agreement, and they say, well, that's okay, you can give your objection when you give your victim impact statement. Well, no, you've lost the right. You lost that moment in time where you had the ability to speak. They are very distinct rights for different purposes. And you don't make amends by saying, oh, you can just do it at the sentencing with the victim impact statement. That doesn't make the victim feel any better, I'll tell you that. But also it doesn't stop the fact that, or alleviate the fact that a right was violated. All right, we're going to move into some post-conviction rights quickly, and I'll highlight some that are particular to sexual assault cases. So first, there's an automatic right of the victim to get a notice by the prosecutor of the final disposition of the case. The judge is required to give notice to the victim if in cases of sentence modifications for felonies and crimes of violence. This is problematic because judges typically don't know how to contact the victim in these cases, and we rely on the prosecutor to provide some kind of notice to the victim. The prosecutor is required to give all victims in cases of appeal notice of the petition, the victim's right to be present at any oral arguments, the disposition of that appeal, and the release of a defendant as a result of the appeal. This is automatic. The victim does not have to opt in. There's also a notice of the victim to get notice, a right of the victim to get notice of a petition for expungement. This is an opt-in, meaning the victim has to ask the prosecutor, if there's going to be an expungement, you let me know, you give me notice of that, and then the victim has certain rights to be heard in that expungement proceeding. Keep in mind though, for CSC crimes or any crimes in which the person is required to register as a predatory offender, those crimes are not eligible for expungement. So even if the person was charged with a CSC crime, but pled guilty to something lower than that, that might normally be eligible for expungement, if that person still is required to register, that's going to prohibit them from getting an expungement of the record. Just want to note, even though this doesn't apply to CSC crimes, there's also something called an expungement by agreement, that the prosecutor and the defendant can come to an agreement about there being an expungement without requiring the defendant to go through the process of petitioning for an expungement. In those cases, it's not opt-in. That provision does not require the victim to ask to be notified. The prosecutor should or must notify the victim of those expungement by agreements. I'll also note that there's currently a bill going through the legislature that would require or that allows for automatic expungements of certain crimes after a certain period of time without requiring a petition. In those automatic expungements, again, those are not going to be our criminal sexual conduct crimes would not come under that automatic expungement provision should it pass. Is there a question?
Oh. Is the question that you mentioned earlier for protecting an employee from retaliation due to attending an OFP HRO criminal case something that an advocate could send if there's no prosecutor involved?
Sure, why not? You could just take it. You certainly wouldn't say you're a prosecutor, but you can just say, hey, employer, here's the law, just letting you know, right? And you CC the county attorney or the prosecutor so that they're alerted, and that gives a little extra oomph to the letter that you send to the employer. And when Amy next talks, I will go and look for that link if I don't screw up my screens too much. All right. Notification
No,
after.
We can
Yes.
include it in the Dropbox
Okay.
after we're done and the recording goes out.
Excellent. So then there's some additional notification rights that are particular to CSE crimes. So first is the civil commitment. A prosecutor must notify a victim of a petition for civil commitment and the outcome of that civil commitment. It's in a state of flux. It used to be opt-in, then it was automatic. It's probably going to go back to opt-in shortly. But in any case, victims should make that request just to be safe. Civil commitment for can happen typically following a person's incarceration in the Department of Corrections. So for those serious crimes, they'll typically serve their time first. Then the prosecutor makes the decision about whether they'll file for a civil commitment. So this can happen many years after the defendant had been convicted. For that reason, it's important for victims to understand this right, and also the fact that they have to let the prosecutor know of their contact information if they want to get notified of a civil commitment petition. After that person has been civilly committed and is now under the authority of the Department of Human Services, should that person ever have a release or change in status of their commitment, they might get on a pass, they might get a lower security level. If there's a change in status, if the victim wants to know about that, they have to make a request to the Department of Human Services to get notified of that. So it's an opt-in. For certain predatory offenders, those typically with the CSC crimes, the DOC has additional requirements to provide some conditional release notification or conditional release information, and about the release of offenders, some additional things that they have to do. But also, when that person gets released into the community, a victim can request additional information from law enforcement about that offender, including location of the offender. Again, this has to be a request by the victim to either the DOC or law enforcement. And finally, there's a provision related to a confidential request for HIV testing of the defendant. That too is opt-in. And just quickly, it doesn't happen very often, not that I've heard. The examples that I've heard have been mostly from Hennepin County, but a victim does have a right to make a request that the offender who has been convicted of a CSE or other violent offense where there's been evidence of exposure, that they can have the defendant tested for HIV, and that result of that test can be provided to the victim under a certain process that is victim-centered. Okay, just like in the pre-trial phase, there is a provision about a right to notification of release. And in the pre-trial phase, it was automatic for domestic abuse and violent crime victims. In the post-conviction phase, a victim has to opt in to get notified. So upon request, the victim should be notified of the release, transfer when custody status is reduced, or escape of the offender from prison or custodial institution. Again, applies to juvenile offenders. So we talked about VINE as the service. That still applies in post-conviction. If the person was sentenced to a jail term, then the victim must make a request to that county jail facility. But if the offender has been committed to the Department of Corrections, then the victim needs to connect with the DOC Victim Assistance and Restorative Justice Program to make a request to get registered in the Minnesota Haven system, so that they will start the process of making those requests to get notifications that are allowed for DOC offenders. If the person was in a county facility and got transferred to the DOC following conviction, VINE would issue a notice saying, oh, they've been released and transferred to the DOC, but that registration ends. All registrations for further notifications for victims related to offenders in a DOC facility must register with the Minnesota Haven system, and it's opt-in. They have to affirmatively go and make that request. Right, I'm going to quickly go through reparations. This is not a reparations training, but I have the information in these slides, but I wanted to highlight just a couple things related to CSC victims. So reparations is our statewide financial compensation program. Every state has one. It applies to victims, family members of a victim, and persons who discover a body and witnesses to a violent crime. For crimes, they have to be crimes committed in Minnesota, and two basic eligibility rules are that victim must report the crime to law enforcement within 30 days, and the application for compensation must be submitted within 3 years. However, for CSC cases, the 30-day requirement is waived. So if the victim of a criminal sexual conduct crime does not report it right away, that won't prohibit them from making a request later. However, the 3-year limit still applies. The only modification for the 3 years is that minor CSC victims, they have 3 years from the date of the report to be able to file their claim application.
Do you want to do a quick reminder of the difference between reparations and restitution?
Sure. So restitution is a request that is done through a criminal court, criminal proceeding. When an defendant has been charged and convicted, restitution is ordered by the court as part of the sentence as for out-of-pocket losses related to the crime. So that could be medical expenses, property damage, lost wages, all host of things for those out-of-pocket losses related to the crime. Reparations, in contrast, does not require that the case actually be charged and prosecuted. Victims can apply regardless of the charging status of the case. And it only applies to victims of violent crime. And it is for out-of-pocket losses related to those things, not non-property losses. So it's going to be medical expenses, lost wages, loss of support, counseling expenses, and we'll talk about those in just a minute.
And reparations isn't paid by the defendant. Restitution is paid by the defendant.
That's right. And you don't have to wait to get paid. The reparations can pay for those expenses right away, as opposed to restitution, where you have to wait for the defendant to start paying the amount owed. So,
but you do have to report to law enforcement, even if it's not charged. That doesn't matter. But you have to make the report to get.
That's one of the basic eligibility rules. The victim must cooperate with the police. That was here. You must report the crime. That is a hard and fast rule. And you must cooperate with the police and cooperate with the prosecutor and agree to pursue charges. That's not waived. Like I said, these are crimes covered by reparations, basically violent crimes. The only non-kind of violent crime is going to be a motor vehicle crash, like a DWI, hit and run, criminal vehicular operation, is included in here as well. Keep in mind for the CSC crimes, sexual assault 1 through 5, but also includes age-based criminal sexual conduct crimes. So we call them statutory rape, where the charge is based on the age distinction of the victim and the offender. So other reparations of requirements, the victim was not committing or trying to commit a crime. That results in a complete denial of the claim, and the victim was not engaged in contributory misconduct. However, the crimes that were committed, it does not include status offenses for the CSC victims. So curfew and underage consumption will not come into play with making decisions about eligibility. There's also contributory misconduct that can reduce the amount of compensation that might occur, but generally failing to retreat in alcohol, drugs, generally not considered for CSC and DV victims. Quickly, you have to use your own insurance. There's a maximum amount that might get paid per claim and a minimum of loss. So these are the kind of expenses that are covered: ambulance, funeral expenses, accessibility, forensic exams, what's not covered by the county, related to the hospital visit, I should say, lost wages, all these kind of things. Just want to highlight things that aren't covered: property loss, basically, pain and suffering, things like that, security systems. All of these things on the list are things that can be asked for restitution aside from pain and suffering and moving expenses. But these out-of-pocket losses that are property related can be asked for in restitution, but you can't get them in reparations. And the three highlighted ones are the ones we might see with sexual assault victims. Any questions before I move? That was done quickly. Okay. So shifting gears a little bit from reparations, just wanted to touch briefly on data, which is actually one of my favorite things to talk about, but I only have 2 slides. So with regard to data, I just wanted to highlight some protections or not protections related to victim data. So first, when we talk about law enforcement data under the Minnesota Government Data Practices Act, sections 1382, covering all law enforcement data, these are the protections. First, you have anything related to information related to the CSE victim is automatically withheld by law enforcement from their reports that will get distributed. So you won't have victim information released. Information about victims of child abuse and neglect is automatically withheld. The identity of a juvenile witness can be withheld if law enforcement agency determines that the subject matter of the investigation justifies protecting the identity of the witness. So that's a discretionary provision. And some counties I've heard, sometimes they just say juvenile witness, we're not gonna release. Other ones make the call based on the circumstances. And then of course, victims and witnesses can request from law enforcement that they withhold their identity from the public. So that's a standard for any type of crime.
We have a question.
Mhm.
A question about the right to break a lease. Would someone still qualify for breaking the lease if the victim was a minor sexually abused by the parent, but has since moved out? Would other parent and other kids still be able to break their lease to keep themselves safe from the abuser?
So there are provisions within that statute about if you're the sole tenant versus not the sole tenant. And guess what? I don't know the answer to that, but I'm going to throw it back to Amy. Do you know?
I don't know. You can call our housing team at Standpoint and they will know. I do know that it depends on the definition of victim, and victim is defined differently all over the statutes. And so it depends if a sibling of or family member of the victim counts as a victim under that statute. And I don't know the answer either. Sorry.
Yep, that's a good one though. Hey, yay, throw me a hard one. Keep them coming, I guess. So
Jay threw in the link to our housing team. Thank you, Jay. So you can connect there to reach them.
And we are so thankful you have that specialty at Standpoint that we can refer to, because we do get these kind of calls as well. So there are a lot of myths about court information. So typically we don't call it court data. It's court information, what the court holds related to criminal and civil cases. And they have a whole set of rules about accessibility of that data to the public or not. What we can see, what the public can see, and what they can't see. There is no provision about the protection of information related to victims, except for this one thing, 2 things, but primarily this one thing: minor victims in certain sex offenses. So the identity of a minor victim in a criminal sexual conduct case where an offender is charged with CSC crime, not including 5th degree, I don't understand that, sex trafficking or criminal sexual predatory conduct, that's not accessible to the public. That is the only provision that says that protects victim information. And as I always said before, a victim can make a request for HIV testing, and that whole process is confidential. Even though we only have that one provision about protection of victim information, there are practices out there that can protect victim information. So let's talk a little bit about what is accessible to the public unless it's filed as confidential or under seal. So victim information filed with the court, except those noted CSE victims, information in an OFP and HRO, including information on minor victims. So You could have a criminal case with a minor CSC victim where they don't share the information, but if parent files a petition for an OFP against the offending parent and puts the names of that minor victim in there, as well as the details about the sexual assault, that is not, there's nothing to protect that. There's no provision protecting that. The only way you can protect it is if you filed it as confidential or under seal. The contents of a DANCO is accessible to the public. A written victim impact statement or the transcription of an oral victim impact statement given at sentencing, that's accessible to the public. So unless you have something filed under seal, all this information is going to be accessible. Now, there are practices that can protect victim information. For example, in complaints where a prosecutor submits a complaint with victim 1 and victim 2, we strongly urge people not to say victim AB with the initials and HC, and having identifiable initials or ages or dates of birth. Not a good idea, because especially in smaller towns or by virtue of the complaint that has been filed, for example, significant relationship between the victim and the perpetrator, you don't want to have anything that might identify that victim. There's no rule prohibiting or expressly permitting the use of initials or generic victim identifiers in court filings. There's just a practice, and you see that all the time, practice of not having identifiers. What this speaks to is careful practices by prosecutors when filing complaints and court documents, and also for advocates about how they file OFPs and cautioning their clients about what is put in an OFP and how you might describe things in an OFP, knowing that it's a public document overall. So we're going to wrap this up with just some tips for advocates, our prevention guidance, we call it. Amy, I'm going to let you start. Go wherever you want with this.
Okay. So like we've been talking about the whole time, the whole point is to try to keep rights from being violated, to prevent harm, and to support victims through this whole process. So getting victims connected to the right person, so they're not having to have a runaround and try to figure out who to talk to, is really important. And again, knowing in your community who's the right person to talk to, having those relationships and building up those multidisciplinary teams really helps with that.
And I always say that being a good victim advocate is being a good victim educator, educating them about the reality of the system, how it works, and knowing how it works in your particular location, and dispelling myths for victims about what they think is going to happen, so that they don't get frustrated because what's happening isn't going according to what they thought was going to happen.
And having those disciplinary teams in your community is going to help you also see where the issues are and where you or your agency can be doing some educating or working to prevent the problems in the courtroom or the process for victims in reporting sexual assault. You're going to know where those holes are and have the right relationships to try to stop them.
And that might mean those proactive steps might be telling your victim, because you know how it works in your county. You say, every victim, you say, call the prosecutor the night before and say, you're coming, and that you're going to be wearing a blue jacket, and they're going to be looking for you. And who am I supposed to check in with and find out, is it the bailiff? Is it the court reporter? And with Zoom calls, who is it that you need to connect with? And really trying to figure out how to reduce the chance of a victim rights violation.
And giving victims guidance on effective communication with the systems professionals can be really helpful as well. How you approach somebody, how you ask for something, how you demand your rights can make a big difference in how the victim is treated and how they experience the process.
Yeah. And when things go wrong, sometimes they do, encourage victims to keep the lines of communication open with those criminal justice professionals, seek the help of advocates or my office. We do this, saying, how can we reconnect the victim with the prosecutor to make sure their rights are upheld, even though there's been a conflict, or even though the prosecutor's mad at the victim because of saying something that wasn't very nice, or all those kind of things that might happen. How can we keep the lines of communication open to make sure the victims still have their rights upheld?
And again, I keep saying this over and over. I feel like a broken record, but it's just so, so important. I was a prosecutor for a long time, and I was in domestic abuse and sexual abuse, multidisciplinary teams. And knowing who else is out there within the criminal justice agencies and community-based programs to support victims and having those relationships is really important. We're all in this together. We're all on the same side. We're all in the same team wanting to support victims and getting justice for the offenses and the harm that's occurred to them.
So lastly, just reminding you that we have resources. They're going to be shared with you. Both Standpoint and the CVGAU provide lots and lots of technical assistance to the victim service community. We're always willing to answer questions about crime victim rights. The CVGAU, and I know Standpoint, answer questions of all sorts, and that's what our jobs are, is to provide that assistance. So with that, I'd like to say thank you, and our contact information will be included with the PowerPoint handout, and thanks for attending.
Thanks for coming, guys. Have a great day.
Thank you so much. Thanks, Suzanne, for joining us today in this webinar, and Amy for the great presentation. I don't see any further questions, so I will now end the webinar.